Okay, so good morning, everyone. Thank you for joining us today for HR Matters Employment Law Changes to Watch Out For in 2021, presented by the Sheffield Employment Team. Before I hand you over, if you've got any questions for any of the panellists, please use the Q&A function at the bottom of your screens. If you've got any technical issues throughout, please use the chat function and I can answer these. I'll hand you over to Tom. Thanks very much.
Great, thank you, Tom. Welcome everybody to the HR Matters Employment Law Changes to Watch Out For in 2021. For those of you who've tuned into the Freeths Sheffield office HR Matters webinars before, you'll know that I am Tom Draper, Director and Head of the Sheffield Employment Team. And I'm joined this morning by Toby Pochron, Managing Associate, giving everyone a wave there, and Lee Williams, who's an associate as well. These are two of the five members of the Sheffield Employment Team. We also have Elizabeth Ferguson and Sahir Hamer. Those of you who tuned in every month for HR Matters will note that the absence of Elizabeth this morning, she has gone on maternity leave now, and she'll be back hopefully this time next year. So why are we looking this morning ahead to the changes for 2021? Well, hopefully, most of you will be in agreement that we want to put 2020 behind us and look forward. So this is the time of year when we make New Year's resolutions, and hopefully it will be your New Year's resolution to watch more HR Matters webinars. So we thought the right place to start would be to look ahead to 2021 and explore what the employment law changes have in store for us and how these affect your organisation. As Tom's already said, if you've got any questions, please do use the Q&A function in Zoom. I'll be astonished if there is anyone on this call who hasn't used Zoom before. So hopefully you'll be very familiar with the Q&A function. We will come to your questions at the end, and I know that we've had a few questions ahead of this webinar, which we will also look at then. So we are looking to finish this session at 11:30, and we will be covering everything that we think is going to be interesting and important for your organisation in terms of HR and employment law. So we're going to start by looking at an update on the coronavirus job retention scheme. We did try to make this webinar COVID secure by avoiding mentioning coronavirus, but it has unfortunately slipped in there in terms of the first topic that we are looking at. The second topic is we're looking at the extension of the IR35 rules. Then we're going to look at public sector severance payments, and then look at any other changes to look out for before we finish up by looking at Brexit and what the recent Brexit deal means for UK employment law. So the coronavirus job retention scheme, I'm sure everybody will be very familiar with what that is. And as a result of the recent lockdown, it's been extended to the end of April 2021. So it's anticipated that the government will continue as it is now to pay 80% of the salary of employees for hours that they haven't worked when they're placed on furlough. This is capped at £2,500 a month, and employers are required to pay employer national insurance contributions and pension contributions for those employees who are furloughed. The eligibility criteria for the current furlough scheme is that the employee must have been on the employer's payroll on the 30th of October 2020, and that employees can be furloughed for any shift pattern. So this is an extension of the flexible furlough scheme that came into operation towards the back end of 2020, where you don't have to have employees full-time furloughed. They can be furloughed on a part-time basis, but it's very important that those employees do not carry out any work for you whilst they are on those furloughed hours. And finally, the furlough agreement must be confirmed with the employee in writing. Obviously, the intention of the furlough scheme is to compensate employers whose businesses have been adversely affected by COVID-19, and particularly the lockdown restrictions that are currently in place. There has, however, been some useful updated guidance from the government recently in terms of the types of employees who can still access the furlough scheme. And these include employees who are unable to attend work because they are clinically extremely vulnerable, and employees who have caring responsibilities as a result of COVID-19, such as caring for children who are at home as a result of school closures. And I know that I've had questions from clients about those two categories of employees recently, and whether or not the furlough scheme could extend to those employees. And so the recent government guidance is welcome to confirm positively that the coronavirus job retention scheme does extend and can be used by employers to cover those types of employees. I think particularly interesting here is the question about when employers should furlough employees with caring responsibilities. I know that lots of my clients have had employees approach them and request to be furloughed in this type of situation. And I know from having a young family myself that there are difficulties that are caused by having the obligation as a parent to home educate your child at the same time as trying to do your job. And I know that Toby is grappling with that at the moment with his young son, who has been sent home from school as a result of his bubble being compromised. And so employers instinctively, I think, have sympathy with employees in this situation, but it isn't always possible to agree to furlough them. So my advice to employers where they are approached by employees requesting to be furloughed is to treat this as if it were similar to a flexible working request. So look at the impact on the business, have a meeting with the employee. It doesn't need to be a formal meeting, but it would be a good idea to make a note of it and look at the impact on the business, the impact on the employee, and weigh up sensibly and reasonably whether or not the employer could agree to furlough the employee. And that way, you won't be making a precedent for other employees, because I know it's a big concern of employers that if they say yes to furloughing one employee, this then might result in other requests from other employees. I think it should be treated on a case-by-case basis, and therefore, hopefully, you'll put yourselves in the best position to avoid employees resigning and, in an extreme situation, potentially claiming constructive dismissal. I think the key is to show that you've considered the request carefully and reasonably and documented your approach. So I heard on the news this morning that the CBI is pressuring the government to extend furlough until the end of June, and then even after that in respect of industries that have been particularly badly affected, such as retail and hospitality. And they were also asking for more support from the government in respect of some of the other loan interruption schemes and business bounce back loan schemes that the government has got currently in place. And we will wait to see what the Chancellor says in his budget on the 1st of March in respect of not only what's going to happen in respect of the coronavirus job retention scheme, but also some of those other business support packages that the government has put in place. So let's just have a look now at the next slide, which is about IR35. So IR35 is the off-payroll working rules. These were first introduced in 2000. IR35 is the name that's been applied to this. It was first used in an Inland Revenue press release, which is where the IR comes from. And essentially what it is it's the name given to the anti-avoidance measures designed to reduce tax avoidance by off-payroll workers. So that is workers who are engaged through an intermediary. Often a worker will incorporate a company and provide their services through that company to an end user. And what the current IR35 rules do is they place an obligation on the worker to determine their own tax status. And HMRC have done a review of this, and they've said that they think that possibly only as few as 10% of people who are working in this way are paying the correct level of tax and national insurance. And so in order to try and recover some of what HMRC sees as the underpayment of tax and national insurance, they are changing the IR35 rules to place the obligation on the end user to determine the tax status of any individual working for them through an intermediary company. And so let's have a look before we come to the implications of getting it wrong. Let's have a look at who these changes apply to. So there is an exemption for small companies. The new rules only apply to medium and large businesses in the private sector. There has been a change to the public sector IR35 rules for some time, and the extension of the IR35 rules, which is coming into force on the 6th of April, will extend this to the private sector as well. So the small company, in order to be exempt, small companies need to have 2 of the 3 following criteria: turnover of no more than £10.2 million, balance sheet profit of no more than £5.1 million, or not more than 50 employees. So if your organisation doesn't have 2 or more of those 3 criteria, then the extension of the IR35 rules won't apply to you. However, I think it is only a matter of time before the changes to the IR35 regime is extended to all employers. If it's not next year, it might well be the year after. And so I think it's worth all private sector employers getting to grips with these changes and having a think about how they're going to impact their business. So how do we look to determine whether or not someone falls within the IR35 rules? If this is going to be our obligation as end users of people who operate in this way, then it's important to know the answer to that question. And as part of the process of assisting employers with this decision, the government has come up with the Check Employment Status for Tax tool, known as the CEST tool. And this can be accessed on the HMRC website. And it is a series of questions which will produce either a positive result, which means that the IR35 rules do apply and the individual should be paying PAYE tax, or that they don't apply and that the employee is self-employed for tax purposes. And sometimes the CEST tool comes out with an indeterminate answer, which is very unhelpful indeed. And as long as employers have put in a true record of the information that they have and have shown a due regard and acted in a reasonable way when completing the CEST tool questions, HMRC have confirmed that they will stand by the results of the CEST tool. And so if you've decided as an employer who engages people on this basis that you are going to provide these status determinations, then it's important, obviously, to keep a record not only of the outcome of the CEST tool, but also where you got the information from to answer the questions as part of the CEST tool process. So once you've gone through that process, it is important that employers then send what's called a status determination statement to the individuals that they engage in this way. And the legislation provides that employers are required to put in place a mechanism whereby individuals can dispute the status that the end user has applied to them. And so there needs to be some form of appeal mechanism in place whereby people who are engaged in this way can write back to us as end users and say, well, we disagree with the status determination that you've come to for these reasons. And then there is a 45-day period within which the end user has got to provide a final status determination to the individual. Now, I know that a lot of my clients have decided, in the face of having not only the risk, but also the administrative burden of going through this process, in the face of that, they've decided to drop engaging people in this way completely. And they've either decided to move people onto PAYE or dispense with their services entirely. Now, that could potentially lead to problems, particularly if people who've been engaged in this way have been engaged in this way for a while. They may well get upset about having their services terminated, and they may start looking into whether or not they were genuinely self-employed as they claimed, or whether or not they were an employee. And this would potentially result in people who've been engaged under the IR35 regime from saying, well, actually, I think that termination of my services was potentially an unfair dismissal. And if I'm an employee for tax purposes, then I might be an employee for employment law purposes, and that termination was therefore unfair. Now, obviously, whether or not that's the case will depend from situation to situation, depending on the facts. But the implications of getting this wrong could be potentially quite significant. HMRC have said that they will not chase employers for backdated tax and national insurance. That isn't yet written into the law. That is just what HMRC is saying, and they have been known to change their mind in the past. But at the moment, all the indications are that they won't be chasing employers in this situation if they decide to change the employment status of individuals working through intermediary companies. But that doesn't necessarily mean that there won't be employment law implications. So where we have just a kind of binary position in respect of the tax status of individuals, so they can be employed or self-employed. In employment law, we also have this intermediary category called a worker. So if people are neither employed nor self-employed, they could be a worker. And the significance of being a worker, you don't have the right to claim unfair dismissal, but you do potentially have the right to claim backdated holiday pay. And that could be quite a significant amount of money, depending on how long employers have been engaging workers through intermediary companies. And obviously, if you've got numerous people working in this way, all of them potentially claiming backdated holiday pay, then the significance of changing their employment status could be quite significant. So I know that at least 2 or 3 of my clients have come to me with this problem, and we're quite well positioned at Freeths in Sheffield to have a large tax law team, and I've asked our tax experts to have a look at this situation for my clients and see what can be done to mitigate the risks of people being found to have employment status from an IR35 point of view. So it's worth thinking about. Just as a reminder, this is coming into effect on the 6th of April. And if your organisation isn't one of those exempt employers, then these rules will apply to you. So that was a quick run through IR35, and I'm now going to pass over to Lee, who's going to look at public sector payments. Thanks, Lee.
Thanks, Tom. So I'm going to start today by going through some recent changes to the law in relation to public sector severance payments. So this is not strictly a 2021 law change to look out for, as these rules actually came into force at the back end of last year. But with a number of redundancies likely as a result of the effects of the pandemic on things like budgets, it's increasingly likely we will witness some more of this in the public sector over the coming months. So for those who do keenly follow the news, these public sector severance payments have been quite a controversial topic for long before all the pandemic. There's accusations that they're actually out of step with the payments what are made in the private sector, and as such they're a bit of a waste of taxpayers' money, and often some of these payments can be quite astonishingly high. So in November last year, new rules came into force in the form of the restriction of public sector exit payments regulations 2020. And in summary, these regulations restrict severance payments made in the public sector to employees when their employment terminates to £95,000. I say most employees because some organisations are excluded, universities, for example, but on the whole, the scope of the regulations is quite broad. So what payments are covered in this £95,000 cap? Some of the most common payments that will be included include things like redundancy payments, payments in lieu of notice where the payment exceeds 1/4 of the employee's salary, any payment in the form of shares or share options, payments due to extinguish liability under a fixed term contract, and voluntary exit payments, settlement payments, and this includes payments made through ACAS, and any other payments, whether under the contract or otherwise, in consequence of the termination of the employee's employment or loss of office. There's various other payments what will be included, but these are the main ones what employers are likely to come across. There are some payments what don't fall within the cap, and some of the main ones of these include death in service payments, incapacity payments as a result of accident, injury or illness, payments in lieu of accrued and untaken holiday, and payments made in compliance with an order of a tribunal or a court. So these payments do not need to be considered when determining whether that £95,000 cap has been met. On top of this, there will be some cases where the £95,000 cap will not apply at all. I don't intend to go into too much detail on these, but the main ones, what you would be expected to come across are where an exit payment is made as a result of TUPE, and where a payment is made to avoid employment tribunal litigation in relation to a detriment or dismissal due to whistleblowing, a detriment or dismissal as a result of certain health and safety activities, and as a result of a complaint under the Equality Act 2010, so discrimination. But to make sure these exceptions aren't abused, specific ministerial clearance will be needed. And to get this, the employer needs to draft a business case showing why the cap should be raised in the circumstances. And this would, in getting this business case, for one, you'd probably be expected to get legal advice on the merits of any claims, what could be brought, and the potential value of these claims. So the bad news for employees is that their employer cannot just raise a cat just because they've made a complaint about discrimination or health and safety. They would need to go through these hurdles first. So that's all I'm going to cover on this topic. I appreciate this won't be relevant to a lot of people on the call, but for those who do want to find out more, we've put a link on the slide, and the government has published some detailed guidance on these regulations. So if you click the link, you can find out more there. But for now, I'm going to move on to the next topic of the webinar. So Tom, can we have the next bill? Thank you. So as you can see on the screen, the next thing we've identified as potentially something to look out for in 2021, a development around ethnicity pay gap reporting. So as some of you will know, particularly those who work for larger employers, since 2017, organisations with more than 250 or more employees have had to report their gender pay gap. And this is based on the difference between what the organisation pays to women and men. This is not the difference between what the employer pays men and women for carrying out the same job. This would fall under existing equality law. In this context, what gender pay gap means is the difference between the average earnings of men and women across the whole workforce as a whole. So since the introduction of gender pay gap reporting in 2017, the government's consulted about whether this should be extended to reporting ethnicity pay gaps within larger organisations. And this is on the back of research that has showed that Black, Asian and minority ethnic workers are often paid significantly less than their white counterparts. So the government consultation on this actually ended in 2019, and we were originally due to hear the response at the back end of last year. Unfortunately, we've not got this yet, probably due to the government focusing on other things like Brexit and the pandemic. But given the recent spotlight in this area on race inequality, we probably can expect some developments in this area in the not too distant future. And I understand that a lot of large employers are actually already calculating their ethnicity pay gaps in anticipation that the law will change in this area. So some organisations are trying to get a head start before they are forced to calculate this data. So that's it on that one. Can we have the next slide, please, Tom? So still on the subject of equality and discrimination, the next potential development in 2021 that we've identified for the purposes of this webinar is in relation to the redundancy rights of pregnant employees and those on maternity leave. So currently, despite what some people believe, there's no automatic right for a pregnant employee or an employee on maternity leave not to be made redundant. If a redundancy situation does arise in these circumstances, then these employees will be considered for redundancy in the same way as other employees who are not pregnant or on maternity leave, subject to a few exceptions. And the main exception is that if an employee on maternity leave is selected for redundancy, they have an automatic right to be offered any suitable alternative role that comes up in priority to other potentially redundant employees. So this means that if a suitable job comes up and the employee on maternity leave is selected for redundancy, she should be automatically be given the job without having to apply for it. But some people believe that this protection doesn't go far enough. For one, it only applies to employees on maternity leave. It doesn't apply to pregnant employees or those who have just returned from maternity leave. Second, it doesn't, in practice, employees are not even aware, sometimes employees are not actually aware what rights they do have. So if their rights are breached, they will not be aware of this, and this can then lead to other situations of discrimination against pregnant women and those on maternity leave. So to help combat this, a bill is currently going through the Commons called the Pregnancy and Maternity Redundancy Protection Bill. And this bill aims to completely reform the rights of pregnant employees, employees on maternity leave, and those who return to work after a period of maternity leave. In short, what the bill proposes to do is to provide women from the day they become pregnant until 6 months after they have returned to work from maternity leave with the right not to be made redundant unless the business is closing down or ceasing work in the area in which the woman works. So this would protect, for example, a pregnant woman in a restructure scenario where the employer wishes to remove the employee's role but still continue operations in the employee's area of work following the restructure. If a woman experiences a stillbirth or miscarriage, they will also be protected by the proposed new law. And this protection would extend to 6 months from the end of the pregnancy, or any leave that the employee would ordinarily have been entitled to take. But unfortunately, again, probably because of the pandemic, there's been some delays in getting this bill through Parliament, but it does appear that the bill has cross-party support. So there is a good chance that we'll be seeing at least some changes in this area in the not too distant future. And for those who are really interested, we've helpfully put you a link on the slide. And if you click that link, you can monitor the progress of the bill as it goes through the Houses of Parliament. So Tom, can we have the next slide, Bill? Thank you. So last one from me today. The next development we've identified as being something to potentially look out for in 2021 is in relation to the rules around continuity of employment. So as we all know, various employment rights depend on an employee's continuity of employment, or in other words, their length of service. These rights include entitlement to various benefits such as maternity pay, statutory redundancy pay, and also the right to bring certain claims in the employment tribunal, ordinary unfair dismissal probably being the main example. And an employee's continuity of employment begins when they start work for their employer, and we usually continue until their employment terminates. However, as an exception, the law currently says that where an employee's employment terminates and then recommences within a full week ending on a Saturday, so less than a full week ending on a Saturday, continuity of employment will be preserved. Anything more than a week in usual circumstances will, however, break that continuity, and the employee will then lose the continuous service. So now if you cast your minds back to 2017, you might remember a gentleman called Matthew Taylor, who undertook a review into modern working practices, or as we now call it, the Taylor Review. And the reason why this review was commissioned was because there were growing concerns that employment law in the UK was not keeping up to speed with changing ways of working. A particular focus was given on what we now call the gig economy. And one of the concerns raised around in the Taylor Review around this was that many employees were working on casual contracts that were being deprived of employment rights because there'd often be gaps in the assignments that they were being asked to undertake. So an employee would undertake an assignment, there'd be a gap of more than a week, they'd start a new assignment, but because of that gap, the employee would be losing all those accrued employment rights. So to give employees more certainty, what the Taylor Review recommended was increasing this break required between assignments to break this continuity of employment from 1 week to a month. And in the government's response to the Taylor Review, which was a good work plan, the government agreed with Matthew Taylor on this and has proposed that yes, the break in continuity required should be extended, not to a month, but to 4 weeks, or close enough. And it's hoped that this would reduce some of the risk on employees who work in this way, where they're undertaking intermittent assignments with gaps in between. We don't know when, again, we don't know when this law is going to come into force, but the government has shown quite a strong previous commitment to implementing the changes proposed under the Good Work Plan. So, for example, last year we saw the introduction of Section 1 statements for all workers and the right to get one of these statements from day one of employment. So it is likely that we will, given the government's commitment, we will see changes in this area in the coming months. So that's something else to look out for in 2021. And that is pretty much it from me today. If you do have any questions about anything I've covered, as Tom says, pop them into the Q&A box and we'll get to them at the end. But for now, I'm going to pass you on to Toby for the next part of today's session. On to you, Toby.
That's great. Thank you very much, Lee. Good morning, everybody. So I'm going to run through a couple of slides here. My first topic is on employment tribunal procedure and what's to watch out for in the next coming years about how the tribunal procedure might change. So in April last year, the Law Commission produced a report into employment tribunal hearing structures. For those of you who don't know, the Law Commission is an independent body that's been set up to review and recommend changes to the law and the way in which courts operate or work. whilst that report itself isn't binding on Parliament, normally those recommendations are at least taken into consideration about what the next steps are going to be for tribunals or for the law. And what that allows us as practitioners to have is a kind of an insight into what we think is probably going to happen in the future. So whilst none of these are particularly binding, none of these are certain, we can view them and say, well, actually, this is probably going to be a move that we might see in the future. So we can keep an eye on those to be able to advise our clients a bit better. So the Law Commission's report into the tribunals found that there are quite a lot of quite unsatisfactory gaps. Those unsatisfactory gaps led to inequalities between employers and employees, and what the Law Commission report was trying to do was to address those. And what it does is it then makes these recommendations. These are the key ones that we think are probably going to be quite relevant. So the first one is to increase the powers of employment tribunals to deal with breach of contract claims brought by employees or workers whilst that employee remains in their employment. So at the moment, what you have to do, say if you're an employee, you've got an issue with your employer, you think they've breached your contract of employment, you've got to leave. You've got to throw yourself on the sword, leave your job, and then sue them in an employment tribunal. Now, the employment tribunal recognised, and the Law Commission report recognises, that that's incredibly daunting. So what it might end up being is a real inequality for someone who's thinking, well, I genuinely have had a part of my contract breached here, but I don't want to leave my employment. What I want my employer to do is to be bound by the obligations to which they've already agreed. So it could be really interesting to have this right put in. I can't quite see how it would generally work. So I have to determine what that clause is going to be. It's still subject to argument between the employer and the employee, but it'd be interesting to see. What it could do is reduce the absolute burden that comes along from having to defend a full employment tribunal claim. Now, what you could then be doing is deciding a discrete fact about which part of the contract applies and what that should be like moving forward. And hopefully they'll be a bit less acrimonious than it is right now. Gives the employee a mechanism to have that dispute resolved rather than launching into leaving, claiming constructive unfair dismissal and having these sort of multi-day hearings. They also looked at increasing the time limits in the employment tribunals as well. So at the moment, time limits are really fine. You've got 3 months from the date of a cause of action to bring a claim. So, date that you're dismissed, date of a discrimination claim. It's that designed, in my view, to give certainty to everyone. Employers, staff changes, get a claim in and it's many years down the line, it'd be completely impractical for an employer to be expected to still have the same employees in place. But the 3 months itself is very fine. It is a really short timescale for individuals to deal with. So what the Law Commission recommended was extending that to be 6 months. So 6 months timetable from our cause of action to be able to bring a claim. Now, that's all well and good. We don't know whether that's going to interact with the ACAS early conciliation procedure, which already extends time limits by at very least 4 weeks and then another 4 weeks, depending on how long conciliation lasts for when the limitation ends. Actually, that's even been extended to be 6 weeks during the current pandemic as well. So we could end up in the future with a lot larger risk periods for employers. At the moment, time limits can be extended if it's just inequitable to do so. So judge could consider whether or not the individual was able to put their claim in appropriately, not just being ignorant of the law, that's not an excuse, but say they were very poorly, not able to contemplate bringing a claim. There was some other real serious adverse life event that would mean it would be inequitable to not allow them to bring that claim. What the proposal was to kind of reduce that, simply have it on the basis of, well, you've got 6 months, you should have known within 6 months' time. So it might make it a bit more certain for employers. But in any event, extending it out at any point adds an additional layer of risk to an employer as well. They also want to increase the employment tribunal's remit for dealing with breach of contract claims for damages. So currently you can bring a contract claim in the employment tribunal for only up to £25,000. That is proposed to be extended up to £100,000. At the moment, if you have an executive who leaves, generally what you end up doing is bringing a claim in the employment tribunal for unfair dismissal, which is a statutory right, which has to be dealt with by the employment tribunal, and excluding a breach of contract claim and bringing it in the High Court or in the county courts. The tribunals are capped at the moment of 1 year's gross pay, and that, or 83,000 and some pence. That can be quite restrictive. It can be quite limiting for employees on large levels of service or large levels of pay. So what you end up doing is having these two concurrent pieces of litigation. That's undesirable, really is undesirable. We don't want to defend a litigation on multiple fronts, especially when you've won one, then you're having to face another as well. Completely separate area of law, different with contract, different with statute. So it makes sense to have it increased so it can be dealt with by a tribunal, and at the very least it's all in one space. They're also advising that employment tribunals should be able to hear claims by employees that their working hours are in excess of maximum working time limits. At the moment, you can only look at that once it's gone, or whether or not there's been a detriment to that person, or this would allow a determination by an employment tribunal about whether that person is being required to work too long. That's probably come from trade union legislation as well. And they're also looking at implementing different ways of enforcing tribunal judgments. It's a real common thing in the employment tribunal that judgments just simply don't get paid. So it can, again, lead to an inequality. You end up spending quite a lot of public money in dealing with employment tribunals, judges and claims, and running those matters through, that all funded by the public purse. And then if that individual can't enforce the judgment against their employer because they're simply not being paid for it, makes a bit of a mockery of that as well. There's already been, higher penalties that have been put in place, but they're looking now at how they can go about enforcing that a little bit better so that compensation is paid in a timely fashion. That's welcomed. It's just, I'm not really sure how they're going to be able to improve the current process, which is already quite quick. We're probably not going to see these recommendations put in place for a fair amount of time. Like I say, they're only recommendations at the moment. It allows us as practitioners to do a little bit of crystal ball gazing and think, well, what are we likely to see in the future? As both Lee and Tom have already said, obviously there are other things on the government's mind at the moment, so it's just something to watch out right now. But they could become more relevant because of the government's commitment to enhancing rather than removing workers' rights following Brexit, which leads me very nicely onto my next slide, which is all about our Brexit update. So I think we've included this slide so that when lockdown finishes and we can all get together and have parties again, you can all start with a nice little icebreaker of, hey, do you know how Brexit affected employment law? And then you can run through these, and everyone at the party will absolutely love you. But I imagine everyone at the party is already on this webinar, so they probably already know. But as we all know, 24th of December 2020, I'm glad I saw Tom give me a laugh there, because there's just no feedback at all. So I think I'm hilarious, but I'm going to say that probably there was raucous laughter across the board. So 24th of December, we reached a deal on leaving the EU. That did impact on employment law. Obviously, impacted on quite a lot of other areas of law as well. But specifically for employment law, there have been some key rights and obligations that have been now set in stone. Right. So there is a commitment from the UK government not to reduce employment law rights. This probably was one of the biggest talking points, especially for employment lawyers about Brexit, was will there be a de-stripping of rights? Will there be a post-Brexit harmonisation about how employees can trade? A lot of speculation in the papers about whether or not the UK would then start to remove employment law rights, or take away what we consider to be EU rights and probably not replace those with UK legislation. Now that's been committed by the government to not take place, right? However, there's some pretty major caveats to that. So in return for tariff-free and quota-free trade deals, the UK agreed to not reduce employment law rights below the standards as they currently existed on the 31st of December if this affects trade or investment and it commits to enforce the generalised laws and standards that are in place at the moment. So this extends to kind of things like the fundamental rights to work, working conditions, and health and safety standards as well. Now, these provisions clearly restrict the UK's ability to make major changes to employment law, but it's not a complete prohibition on weakening employment law rights, because that prohibition would only exist where that would affect trade and investment. It's been agreed that a panel of experts will decide whether or not either party to that, the EU or the UK, failed to comply with its obligations if that cannot be decided through consultation. Now, the EU initially proposed that the UK should be required to stay aligned to EU employment law rights. But as I just said there, the current trade agreement does not require that. Instead, it provides that if the UK diverged significantly away from the EU in relation to employment rights in a way that materially affects trade or investment, that you can take appropriate rebalancing measures in order to address that balance. And that would probably include things like tariffs, in essence. They say, look, if you undermine our ability to trade freely by de-stripping rights from workers, then at that point in time, we'll do something that will shore up the EU economy, right? So any alleged impact on trade and investment, and again, I'm going to quote from this, shall be based on reliable evidence, not merely conjecture or remote possibility. So that really means that the UK doesn't need to follow the European Court of Justice's rulebook in having a sense to try to align directly the exact rights that EU citizens will receive and the exact rights that UK citizens will receive. But if we significantly diverge from those in a way that affects trade, it's likely that would have an impact on the UK economy because tariffs will be put in place. But that would only take place if there's actual proof of that. So it would have to be a change is made, impact is seen, that definitely or materially or evidentially affects trade and investment. And from that point onwards, the EU would then have an ability to go through arbitration and consultation to address that balance, probably quite lengthy. You know, I doubt that's getting done in the course of a week. I mean, Brexit took a long enough time to do. I would imagine some sort of rebalancing exercise is going to take a long time as well. But the reason behind this is to ensure this so-called level playing field, where it's to stop us from doing, and again, we've committed to not doing this, but once we leave the EU, stripping out workers' rights, reducing everyone's pay, undercutting the EU with lower and cheaper labour based on cheaper employment law standards. You know, I don't think that's a big thing because it was so unlikely that was going to happen anyway. There are so many ways in which that can be held to account, either by the current law that's in place, by trade unions, by just simply responsible employers, you know, who aren't going to be de-stripping people's rights just simply because they can. So the existing EU-derived law does remain unaffected. Under the EU Withdrawal Act, domestic legislation in effect that was immediately in place before the 31st of December simply carries on as part of UK domestic law. This means that things like TUPE, Transfer of Employment Regulations, the Work and Time Regulations, which are EU, both remain in force as they are. Any domestic legislation implementing EU rights must continue to be interpreted in conformity with relevant EU law. So it exists on the basis of the fact that it was written by the EU. That means that when we look to interpret it, we're going to rely on what the EU said as what they meant. But also, we as practitioners would look and say, well, when that was put in place, what did it mean to protect? You know, what was the substance of it? What was it really going for? What are the principles behind it? That all will remain. So it allows us a degree of certainty about knowing what EU legislation is going to be like, what the UK legislation is going to be like, and likely how that's going to continue to move going forwards as well. The new rules do include that the Court of Appeal and the Supreme Court in the UK no longer need to follow the exact rulings of the European Court of Justice, the ECJ. That was the case prior, but they can depart from them if it seems right to do so. So as long as it's consistent with the other obligations that we've got, we can depart from that EU law, what the European Court of Justice says, and that allows us to do what Brexit was designed to do, for bringing back in more control. So we're not having to imply exactly what the ECJ says. We can take our own decisions on it if it feels right to do so as well. UK domestic legislation implementing EU rights will become better insulated from legal challenge. That is, that claim against the UK government can no longer be brought on a basis of an alleged failure to implement EU law properly. So all starts and remains with us. Overall, the provisions mean that the UK domestic legislation must still be interpreted in conformity with EU rights that it was supposed to implement, but it can't be struck down or challenged in the same way as it was before. So if new judgments are released by the ECJ, again, this can happen in the future. This is almost certainly going to happen in that we've got a piece of legislation where we've implemented EU rights, and then the European Court of Justice make a decision about how that should be interpreted. The big one that affected employers in recent history was the changes to holiday pay and how that should be calculated. Now, when that occurred, the UK Supreme Court decided one way, and ECJ completely reversed that decision and decided the completely opposite way on the basis of the EU principles. If that happens again in the future, we are not duty bound, the UK is not duty bound to implement the law that the ECJ provides, but it will still remain as indicative of how that law should be interpreted. We can ignore any new EU directives. We're not deciding to adopt those. We're not forced to do so unless we think it will be relevant, or, as I said before, if we think there might be an implication towards trade and investment. So we've succeeded in negotiating away the freedom to be able to diverge from EU law, but what that's almost certainly going to do is cause more challenge. It's going to have us litigating on more issues as time develops. It's going to have us litigating on the changes that laws create. And that is the essence of quite a lot of these higher level types of claims, is the interpretation of what that law should be. So it's not the case that we can simply blind ourselves to the ECJ rulings. It's probably going to be quite likely that we'll still look at those to decide what that law meant, what it was designed to put in place, and then whether or not that has any implications for the UK as well. That is it from me as well. So we have a few Q&As that have popped up at the bottom there. Do you have any further questions as we're going along, or as we're answering them, please do type them all in and we'll try and get through to them all. Thank you very much.
Great. Well, thanks, Toby. I hope I do get an invite to that party. It sounds like riotous fun. Let's have a look at some of the questions that were sent to us before the webinar started. I think one for you, Toby. We had a question that said, how will Brexit specifically affect businesses who employ people from overseas?
Right. I mean, that would be one for our immigration law team. But I mean, if everyone has the settled right to remain at the moment, you're not really going to see much difference. Right now, what they need to be doing is making sure that all of their employees have the current right to work. As I say, if anyone wants to contact us directly, we'll put them on to our immigration law team. We'll be able to properly assess their workplace.
Great, thanks, Toby. And we had one probably for you, Lee. This was on the extension of the gender pay gap reporting to ethnicity pay gap reporting. It's quite a long question, but basically paraphrasing it, why stop at ethnicity? Why not cover some of the other protected characteristics?
Oh, that's a good question. And we had this similar question when gender pay gap reporting first was introduced. People were saying, why don't we extend this to ethnicity pay gap reporting? And when we get ethnicity pay gap reporting, there may be calls for other types of pay gap reporting, religion, sexual orientation, all the other protected characteristics. Some might argue that it shouldn't just be limited to protected characteristics. It might be things like social background, people who leave care, people who look after other people, carers. There's like tons of areas where this could branch out into, and it is likely we will see calls for that to happen. I think at the minute, the government's trying to balance this with the importance of ensuring that employers aren't discriminating and that people are being treated fairly, with the potential burden that this can have on businesses. And I think that's one of the reasons why currently, even with gender pay gap reporting, this only applies to larger businesses, because I think the government recognised that, yes, this is really important, but at the same time, we don't want it to strangle businesses with bureaucracy. So yeah, I do think that there will be debates about whether to extend this further. I think for now, the focus is on ethnicity pay gap reporting, and we are likely to see something on this this year. But yeah, after that, who knows? Who knows where it might go?
Great, thanks for that, Lee. Tom, could you just flick on to the next slide? I'm just conscious that we have directed people to contact us with any specific questions, and so there are the details that you can use to get in touch with us. So the next question that we got as part of the webinar is around flexible furlough, and the question says, further to flexible furlough and not carrying out any work, could you clarify the situation on training, please? Yes, happy to do that. Employees who are furloughed can still undertake training as long as it's directly relevant, agreed with the employee, and doesn't provide services or generate any revenue for the employer. So for those hours where you've got employees who are furloughed, they can still undertake training as long as those three things apply. Looking at the next question then, another one for me on IR35. It says the definition of a small company is the definition of a small company at the time of the Act coming into force or the last published accounts. and how often do you need to check this, as we are on the cusp of the number of employees. So it is in respect of the last published accounts before the law changes on the 6th of April. So if your business has a turnover of 10.2 million or more, or a balance sheet profit of 5.1 million or more, or 50 employees, it needs to have 2 of those 3 things to be a small business. Then in respect of the last published accounts, then the small business exemption won't apply. If the business then becomes a small business in subsequent years, I appreciate we're talking about an employer here who's just on the cusp of this exemption. If your business were to then become a small business later on down the line, it needs to become a small business in 2 subsequent financial accounting periods for it to then qualify for the exemption. So I hope that answers the question. If not, do email me and I'll happily get back in touch with you. And I think we then have a question on maternity. So changes to maternity redundancy. The question is, will this be the law for the next tax year? Lee?
We don't know the answer to that yet. Currently, it's in quite early, even though this has been debated for quite a while now, because of things slowing down with other things on the government's mind. It is quite still early stages of going through Parliament. If you click on that link, what we did put on the slide, you can see just where it is, and there are some other hurdles it needs to get past. So we might see something this year. If things keep getting delayed, it might be next year. But yeah, if you do click on that link, you can monitor the progress of the bill. You can see what different MPs are saying about it, whether any changes are proposed. But yeah, at the minute, it's anyone's guess of when this will be put through. But we would, given it does have cross-party support, we do anticipate that we will be seeing something in the near future, whether it's exactly as I described it or something with a few changes, we don't know. But yeah, I think we can expect probably in the near future we will hear more on this.
Great, thank you, Lee. The final question is around pension contributions. If an employee has opted for a higher matching employer pension contribution and is then furloughed or goes on maternity leave, can the employer reduce the pension contribution to a lower level? I'm almost certain the answer to that is no, but as we've said in respect of tax and immigration, Freeths also has, I'm very pleased to say, a pensions team as well. So if you wanted to email the specifics of your question, then I can get someone from the pensions team to answer that. Great. Well, thank you everybody for attending this webinar. We're going to send round a recording of it to you so you can watch it again and or circulate it to other interested people within your organisation. We are also going to send some feedback forms round. We're particularly interested in how we can make these webinars maximise the impact of them, and particularly interested in to know what topics would be of relevance to you in the future, so that we can keep them topical and relevant. So thank you very much for attending. Enjoy the rest of your day, and the next HR Matters webinar is coming up on Tuesday the 16th of February, and we hope to see you all there. Thank you very much.
Thank you.